What happens if my spouse files bankruptcy during divorce? Have you ever wondered what happens if your spouse files for bankruptcy while you are in the middle of a divorce? This situation can bring about a lot of questions and concerns. Let's break it down so you can understand what to expect. When one spouse files for bankruptcy during divorce proceedings, it introduces a legal concept known as an automatic stay. This is a legal order that halts most collection actions against the person who filed for bankruptcy. In the context of your divorce, this means that any ongoing discussions about dividing property are put on hold until the bankruptcy case is resolved. This pause is meant to protect the assets involved and ensure fair treatment for creditors. However, not everything stops. Issues related to child custody and child support can still move forward while the bankruptcy is pending. But when it comes to dividing property and debts, that process must wait until the bankruptcy is settled. There are two main types of bankruptcy that individuals can file: Chapter 7 and Chapter 13. In Chapter 7 bankruptcy, a trustee is appointed to oversee the case. This trustee identifies and sells certain assets to pay off creditors. If you and your spouse own property together, the trustee may have the authority to sell that property unless it is exempt under bankruptcy law. If your spouse's interest in the property is included in the bankruptcy estate, the trustee can sell it, but your own interest may be protected if it is not part of the bankruptcy. On the other hand, Chapter 13 bankruptcy involves the filer proposing a repayment plan to creditors. The automatic stay still applies here, meaning property division in the divorce is paused as well. The repayment plan can influence how much of your joint property is available for division after the bankruptcy. It is important to note that the divorce decree does not override the bankruptcy process. Creditors are primarily concerned with being repaid, regardless of any agreements made in the divorce. If you are still legally married when your spouse files for bankruptcy, you may be affected by the bankruptcy proceedings, especially if you have joint debts or assets. If you are the non-filing spouse, your credit report should not be directly impacted by your spouse's bankruptcy. However, joint debts may still affect you. Negative credit reporting can occur if joint accounts are involved, so it is wise to monitor your credit and address any issues with legal help if necessary. In practical terms, filing for bankruptcy during a divorce can lead to delays and complications in dividing property and debt. Many bankruptcy professionals suggest finalizing the divorce before filing for bankruptcy. Alternatively, if both parties agree, filing a joint bankruptcy before starting divorce proceedings can help avoid conflicts and ensure a smoother process for both parties. So, if your spouse files for bankruptcy during your divorce, remember that the automatic stay will pause property division. Child custody and support matters can continue, and the type of bankruptcy filed will determine how your property is handled. The bankruptcy process prioritizes the rights of creditors, which can affect the timing and outcome of your divorce settlement. Understanding these dynamics can help you navigate this challenging situation more effectively.